Welcome to Studio CF, the video law blog of Carlton Fields. My name is Dave Walls. I'm a shareholder and product liability litigator at the firm. Joining me is Penelope Dixon, who is also a shareholder and product liability litigator at the firm. The topic of this episode is changes to removal and remand law. It might not have been broken, but it still needed fixing. Hi, Penelope. In late 2011, President Obama signed into law the most comprehensive set of changes to removal law in more than 20 years. Can you give us a brief overview of some of the highlights?
It really depends on what your particular focus is. But on December 7, 2011, President Obama signed into law the Federal Courts Jurisdiction and Venue Clarification Act of 2011. That act made some substantive changes to removal law, which is essentially the process by which one removes a case from state court to federal court so that the federal court is the one that decides the issues at hand. The substantive changes includes changes to supplemental jurisdiction, the unanimity rule, as well as the way you determine the amount in controversy, and the bad faith exception to the 1-year removal upon diversity cases. Furthermore, the Act also made some changes to the splits of authorities among the courts in addressing the issues of the properly joined and served defendant rule, as well as what to do when there are multiple defendants in the case. And finally, an important thing to note is that the Act only applies to cases that are commenced, which is defined by state law, on or after January 6th of 2012.
Penelope, I know that one of the changes affects the resident or the forum defendant rule. How does that rule apply, and what is significant about the Act?
The resident defendant rule essentially states that if there is a defendant that is a citizen of the state where the case is initially filed, then the case cannot be removed. For example, if a case is filed in Florida State Court and one of the defendants is a citizen of Florida, then the case cannot be removed even if there is complete diversity of citizenship. However, under 1441B, there is language that is included that states that the defendant must be properly joined and served. Prior to the Act, there was a split of authority among the courts on whether the "and served" language was a requirement to remove the case. Now, since the Congress has incorporated that language, it is a clear indication that Congress did intend that the resident defendant had to be served in order to prevent removal. Therefore, if there is a resident defendant and they have not been served, you can remove the case.
You also mentioned changes to supplemental jurisdiction. How do these changes affect the established supplemental and independent claim doctrine?
Supplemental jurisdiction typically occurs when a federal court has original jurisdiction over some of plaintiff's claims, but not all of plaintiff's claims, i.e. the separate and independent claim. Previously, in such situations, the federal court could exercise jurisdiction over both the federal question as well as the unrelated state law claim, as long as the issues arose out of the same case in controversy. Under the Act, Section 1441C2 now eliminates the district court's discretion in determining the federal question as well as the unrelated state law claim. So now, while a case can be removed with both state law claims and federal question claims, the district court is now required to remand back the unrelated state law claim. And it is important to note that only defendants that are addressing the federal question issue are required to consent to that removal.
I know that the Act addresses two procedural points regarding consent and the timing of removal relative to service. What is new about those 2 points?
This is not necessarily a new procedural point, but a codification of a long-standing judicially created rule that all properly joined and served defendants must consent to the removal. This is called the unanimity rule. The second procedural point addresses situations involving multiple defendants and when the 30 days to remove began to run. Prior to the Act, there were two schools of thought. The first served defendant rule, which essentially means that the first served defendant has 30 days to remove the case upon service, or the later served defendant rule, which means the later served defendant has 30 days to remove upon service. Congress adopted the later served defendant rule and allows each defendant 30 days to remove a case upon service, and the earlier served defendants can consent to removal even though they did not remove themselves.
Defendants in the courts have struggled for years with the 1-year deadline for removal in diversity cases and the gamesmanship that sometimes ensues. Does the Act have the potential to help on this issue?
Not only does the Act have the potential to help, it actually does help. Previously, defendants were at the plaintiff's mercy in determining the amount in controversy and the plaintiff's citizenship. In the discovery process, plaintiffs would refuse to answer the question about the amount in controversy or the citizenship in order to avoid removal. This Act now addresses that situation and creates a bad faith exception to the one-year deadline to remove based upon diversity. Thus, if a court finds that the plaintiff's counsel engaged in gamesmanship, the one-year deadline to remove no longer applies. While Congress did not provide an exhaustive list of what constitutes bad faith, plaintiffs' deliberate failure to disclose the amount in controversy is a codified example of what constitutes bad faith.
The federal circuits have split in recent years on how to determine the amount in controversy for purposes of removal, with some circuits even split internally. Does the Act clarify what record evidence is necessary to support removal?
Yes, it does. The new Section 1446 C2A states that in removals based upon diversity, other than under the Class Action Fairness Act, court shall deem the sum demanded in good faith in the initial pleading as the amount in controversy, unless the initial pleading seeks 1. Non-monetary relief, such as in a declaratory action, or 2. Monetary relief, but state practice either does not permit demand for a specific sum or permits the recovery of damages in excess of the amount demanded. In either exception, a district court can exercise its own discretion and find an action removable if, by the preponderance of the evidence, the amount in controversy is met.
One last question, Penelope. When can we expect to see courts addressing these changes?
As the Act became effective on January 6, 2012, I expect the courts will be addressing these issues very soon. Practically speaking, the courts will grapple with these changes for years to come as cases make their way through the trial and appellate courts.
That brings us to the end of this episode of Studio CF. We hope you found this discussion informative. Please take a moment to browse our other legal topics and be sure to check back with us each month for new episodes. Thank you for watching.